Hello everyone, today we are going to review the local case of Hew Sook Ying versus Hiw Tin Hee regarding a separate legal entity. So, what are we waiting for? Let's get started. Corporate Law Reform Committee (CLRC) is established to spearhead the review of the Companies Act 1965 with objectives to create a legal and regulatory structure that will facilitate businesses, and secondly is to promote accountability and protection of corporate directors and members, taking into account the interests of stakeholders in line with international standards.
When reviewing and recommending changes to the Companies Act 1965, the CLRC has taken the following factors into consideration. First, modernizing the law by taking into account the advances made in information and communication technology. Second, reducing the cost of compliance. Third, reducing the duplication and conflicts that exist between the various corporate regulatory bodies. Fourth, simplifying the existing operational processes of a company. And fifth, simplifying the current legislative language as used in the Act.
Now, let's move to the facts of the case. Hew Sook Ying, the appellant, purchased a terrace house in Seminyak from a building company of which the managing director is Hiw Tin Hee, the respondent in this case. Hew Sook Ying then claimed she had paid the purchase price of the property and an instrument of transfer had been executed by two of the directors of the company. However, she failed in registering the transfer as there was a private caveat entered by the respondent on the land. The caveat was entered by the respondent under Section 323 of the National Land Code 1965 in his own name for the extra purpose of protecting his personal interests as a shareholder or on behalf of all shareholders of the company. Hence, the appellant applied for the removal of the caveat. Unfortunately, her application was dismissed by the High Court. She later appealed the case to the Supreme Court. Judgment in Supreme Court said that based on the Section 20 Company Act 1965, once the company has executed the instrument of transfer in Form 40A in favour of the purchaser and handed over the origin document of title, the company has no fiduciary duty to challenge the conduct of the company by means of a private caveat for the alleged purpose of protecting his own interests or the interests of other shareholders. Referred to the case Solomon vs. Solomon regarding the separate legal entity, company property is separate from the members of the company, such as managing director and the shareholders of the company. Thus, in this case, respondent's actions is against the Company Act, which is applying the personal interest on the company's property. According to Section 20 of Companies Act 1965, no conveyance or transfer of property, whether real or personal, to or by a company shall be invalid by reason only of the fact that the company was without capacity or power to do the act or to execute or take the conveyance as transferred. It is not true that the correspondent would be without any remedy once the caveat is removed. And yes, that's how the appellant won this case.
While in Section 21, they have introduced about the companies have unlimited capacity. The companies have the full capacity to undertake any business or activity, including to sue and to be sued, to acquire, own, hold, develop, or any dispose of any property, and to do any act which it may do or to enter into transaction. The principle that was applied in this case is from Section 20 Companies Act 1965. So the Act has provided that no conveyance or transfer of property, whether real or personal, by the company shall be invalid by reason only of the fact that the company was without capacity or power to do the act or to execute or take the conveyance as transferred. In Companies Act 2016, under Section 20 subsection D, they have explained about a separate legal entity. A company that is incorporated from the date of incorporation shall be a legal person separated from its members and continue to be in existence until removed from the register and has all the powers of a body corporate.
Reaching to the last part of our presentation, we can comment that incorporation is a separate legal entity which has capacity to enter into binding agreements with other parties through its agent. In the case of Hew Sook Ying vs. Hiw Tin Hee, the managing director, either as an officer of the company or shareholder, has no capacity to challenge the conduct of the company by means of private caveat once the company has executed the transfer of the property. Section 20 of Companies Act 1965 states that no conveyance or transfer of property by a company should be invalid due to the fact that the company was without capacity or power to do the act or to execute or take the conveyance as transferred. Overall, we can see that there is a huge changes that have been made from Companies Act 1965 to 2016 in the terms of company's capacity and its power. Well, that's all from us. Thank you for lending your eyes and ears to watch and listen to our video presentation.